Welcome back. As a reminder, Professor Chimni will deliver his third lecture. We'll take a short break and then we'll launch into discussion. So, Professor Chimni.
Thank you. Welcome back. I'm sure you'll be delighted to know that this is the final. There are no more out. But thank you for being here again. So in the final lecture, I'm content that in view of what I've been repeatedly saying, the intimate relationship between capitalism and modern doctrines of international law, these are not often in a position to help address the multiple crises, especially the life-threatening climate crisis that are a fallout of global capitalism. The reason is that for an effective response requires that these doctrines undermine the very goals and values that they are designed to promote. In other words, as presently framed, modern doctrines do not have the internal resources to curb and reform the logic of capital, that is, to control the excesses of the global capitalist system. To address the troubling outcomes of global capitalism, these doctrines have to be reframed to take cognizance of the dark side of the logic of capital. Put differently, the underlying assumption of the reframing project is the complicity of modern doctrines of international law in the exploitation of weak groups, peoples, and nations, as also, most crucially, nature over time. Instead, these doctrines need to be informed by a truly inclusive and just vision of the global order. Therefore, to begin with, I'll reflect on one overarching doctrine, which is about the basic values pursued by the international community, that is, the doctrine of jus cogens, which has been critically shaped, in my view, by bourgeois ideology and interests. It has been given a circumscribed scope by advanced capitalist states so as to restrict its potential to undermine the global capitalist order. On the other hand, combating the multiple crises that confronts the international community requires that the doctrine of jus cogens be given a forward-looking, positive, and more ambitious content. Therefore, in the context of climate crisis, I'll suggest that a string of doctrines such as no harm, attribution, necessity, and rebus stantibus doctrines need to be reconfigured by foregrounding their relationship with the logic of capital. The exercise will, as I will contend later, have to be extended to other crises and implicated doctrines. It would, in the final analysis, means reworking the fundamental doctrines of international law, such as the doctrines of sources, responsibility, and jurisdiction. To be sure, in that process, complex issues will have to be addressed, but it is time that we collectively attended to them, for what we are seeing is the consolidation of a capital-friendly doctrinal architecture. But before turning to the task on hand, a few preparatory comments are in order. It is worth underscoring that what is not being proposed is a revolution in the doctrinal framework of international law, a utopian project in the present global order, but rather its reform. What is being recommended is also not an entirely novel exercise. By contending that colonialism has been succeeded by neocolonialism, post-colonial nations have for long taken into account the logic of capital in the shaping of international legal order. Post-colonial nations also reviewed in this light the systemic doctrines of international law and incorporated their view in the landmark 1970 Friendly Relations Declaration. In proposing a new international economic order in the 70s, they recognized the need to take cognizance of the inequities resulting from the universalization of capital. The doctrine of special but differential treatment emerged from these different exercises. Even when it came to other doctrines of international law, the debate on the doctrine of acquired rights or the doctrine of compensation in the aftermath of the nationalization and expropriation of property in the immediate decades after decolonization showed that post-colonial nations were aware that their doctrines needed to be reframed, taking into account, as I said, the dark side of the logic of capital. It was no different, as we will see, in the case of doctrine of jus cogens. However, what post-colonial nations and scholars did not undertake is a systematic review of the fundamental or functional doctrines of international law to understand how these had been infiltrated by the logic of capital. The traditional focus on the logic of territory displaced this possibility. The absence of a thick critical history of international law and its doctrines also acted as a constraint. The lack of a deeper engagement with the epistemology of the doctrines of international law prevented an effective methodological critique. As a result, the role of subsidiary sources and bourgeois ideology in the shaping of international law was not fully grasped. Finally, there was not sufficient appreciation that over time, not one or another, but nearly all fundamental and functional doctrines were impacted by the logic of capital. What I'm suggesting now is to undertake, in the backdrop of the turn to history and the emergence of several critical approaches to international law, a review of the doctrines of international law that explicitly takes into account the logic of capital. What I'm proposing is a reframing and reform of the fundamental and functional doctrines based on three basic understandings: a non-reductionist reading of doctrines that recognizes their relative autonomy from the capitalist project, a recognition that these doctrines are the continued subject of epistemic and political struggles between hegemonic and weak nations, as also between dominant and subaltern groups, and last but not least, acknowledgement of the flawed epistemology that informs the doctrines of international law. Once it is demonstrated that the distinction between doctrine and theory, always suspect, cannot be sustained, and that it is not state practice alone that informs modern doctrines, but equally bourgeois ideology, the objection to the reframing exercise by mainstream scholars will carry less conviction. It will also help show that the increasing rigidity between doctrine and theory in the post-colonial era has less to do with the positivist method and more to do with the questioning of the doctrines of international law, many of which have deep roots in the colonial era. Yet, unfortunately, segments of the critical community are reluctant to engage with the possibilities of reform in the belief that no serious change in the doctrinal framework can either be brought about or be meaningful. In my view, this belief has to be reversed, even as the limits of such efforts is recognized. It has to be remembered, and this is important, that perhaps for the first time in history, we have a significant mass of critical scholars and therefore can make a difference. What is more, and this is even more critical, the climate crisis offers an historic opportunity for freeing the legal method and imagination, as there is a global consensus on the threat it poses to life on planet Earth. It is one area in which innovative reform of doctrines may not be opposed by even mainstream scholars of international law committed to a particular understanding of the positivist method. I therefore use the climate crisis to illustrate what I have in mind in calling for reframing doctrines of international law. It is important to emphasize at this point that there's no singular or unique form that a reframed doctrine may assume. In fact, reframed doctrine may assume a variety of forms. It may assume the form of reconceptualizing a doctrine or elements of it, carving out exceptions to a doctrine, giving it a different thrust, adding or dropping prescribed conditions, revising the scope of a doctrine, or redefining the context in which it comes into play, or suggesting a particular rule of interpretation. That is, there is no unique way, there is no one way to reframe a doctrine. The reframing exercise, depending on the doctrine and issue, may assume a variety of forms. Finally, I would urge you to see the discussion that follows as very much work in progress. What I offer are mere clues on the exercise of reframing doctrines. I will conclude this lecture with some final reflections on the 3 lectures. I first turn to the doctrine of jus cogens. The doctrine of jus cogens, as the ILC draft conclusion state, is about the need to protect fundamental values of the international community. For a jus cogens norm to emerge, it must be accepted by a very large and representative majority of states. Following Article 53 of the Vienna Convention Law of Treaties and draft ILC conclusion 7. It goes without saying that the advanced capitalist states will not accept a jus cogens status for any norm that obstructs the reign of capital. For example, these states will not accept a jus cogens norm, however phrased, that declares void ab initio any treaty or state contract unduly contributing to climate change. In order to understand the existing scope of doctrinal jus cogens, it may be recalled that it received an impetus in the wake of the horrors of the 2 world wars. There was a felt need in the international community for higher level norms to deal with racial discrimination, genocide, and wars of aggression. But the doctrine was never meant to address other fundamental issues, such as the exploitation of weak peoples and nations. Therefore, when in the wake of decolonization, the doctrine came to be broadly deployed for that end by global South nations, on which I'll say more presently, and later fearing its use for other causes of global justice, countries such as France, the Netherlands, United States of America, Australia, and Israel have in recent years come to, as an ILC report observes, expressed doubts, and I'm quoting the ILC, expressing doubts as to the viability and appropriateness of the Commission taking up the topic. This is a departure from their position on the idea of jus cogens when it was incorporated into Article 53 of the Vienna Convention on Law of Treaties. Let us spend a moment on the meaning of this change of heart. In an article in the British Yearbook of International Law, Hamid Asif, relying on the positivist tradition to explain the doctrine of jus cogens, suggests that jus cogens status is achieved when legal officials, principally of states, believe, and these beliefs are deemed social facts, that a particular rule is morally paramount. In other words, according to Hamid, and I quote, a rule of international law is jus cogens on the basis of source-based considerations of social morality. The reference to source here is not to be confused with the sources of international law, but is a reference to social sources of morality. As Joseph Raz explains, and I quote, social morality is based on sources such as the customs, habits, and common views of a community. In this instance, what by default counts as social sources, such as in the case of norms of customary international law, is the view shared by advanced capitalist nations. The doctrine of jus cogens essentially reflects the consensus of their legal officials, supported by a group of organic intellectuals, and this consensus eventually gets reflected in the decisions of international tribunals. But returning to the departure of position from the Vienna Convention Law of Treaties on jus cogens, I may say that it's not surprising. The moment the potential of the doctrine began to be tapped by legal officials and international lawyers of post-colonial nations, doubts were expressed on the existence and scope of the doctrine. In the post-Vienna Convention period, as Umut Otsu has pointed out, and I quote, a large number of socialist and third world states saw the concept as a means of reforming, if not revolutionizing, international legal relations. Eminent publicists like Judge Bajawi assigned the principle of permanent sovereignty over natural resources and the right to development jus cogens status. Other eminent scholars, including Professor Ian Brownlee, granted PSNR a candidate status. It is therefore not surprising that the first generation of third world approaches to international law scholars, like George Zabissab, described Article 53 of the Vienna Convention as the greatest triumph of the non-aligned movement. In this backdrop, there arose concerns in the Cold War era that the doctrine could be used to undermine the legitimacy of the global capitalist system. Fabry and Toponi write that while Third World and Soviet bloc states saw jus cogens as a promise to reform and secure their rights, Western countries feared its indeterminacy and risky drawbacks. The anxiety of advanced capitalist nations was that a reworked doctrine of jus cogens could become a tool of resistance of post-colonial nations, not only against an overly demanding capital, but for pursuing other projects of global justice. Meanwhile, feminist scholars called for the reframing of the doctrine of jus cogens. Writing in the early 1990s, Hilary Charlesworth and Christine Chinkin argued that the symbolism of doctrine of jus cogens, and I quote, is totally skewed and gendered, reflecting a male perspective of what is fundamental to international society. In their view, the category of jus cogens would be transformed in a radical way if women's lives were taken into account. It would inter alia do so through challenging the gender dichotomy between the public and the private. It is at this point that industrialized nations not only began to narrow down the list of jus cogens norms, but sought to discredit the very act of the exercise of identifying them. If we look at the recent comments of states on the ILC draft conclusion on jus cogens, you will see that advanced capitalist nations question nearly all the listed jus cogens norms, mentioning the absence of a convincing methodology and lack of sufficient state practice, the same tools that were used against Midjoy. For example, the United States is of the view, and I quote, that the non-exhaustive list proposed by draft conclusion 23 and the accompanying draft annex both should be deleted. That list at present includes the prohibition of aggression, the prohibition of crimes against humanity, the basic rules of international humanitarian law, the prohibition of racial discrimination and apartheid, the prohibition of slavery, the prohibition of torture, and the right of self-determination. Delete. The United States is willing to assign only one norm to jus cogens status, the prohibition against genocide. It pointed out that while the United States recognizes the right to self-determination, we question whether this right constitutes a jus cogens norm. It concluded, and I quote again, it is unclear whether and how states would determine what the fundamental values of the international community might be. The US was not alone in expressing its reservation. France also observed that, and I quote, the indicative list of jus cogens norms be removed from the draft conclusions. UK was also of the view, and I quote, that a list is not essential to this topic and that it should not be included in the draft conclusions. Australia was equally, and I quote, doubtful of the utility of the non-exhaustive list referred to in draft conclusion 23 and annexed to the draft conclusion. Israel noted that, and I quote, the special rapporteur has relied greatly on theory and doctrine rather than on a survey of state practice, which in our view should be primarily the focus in the present context. Netherlands called on ILC, and I quote, to further elaborate on the fundamental values which serve as the basis for jus cogens and which parts of these fundamental values are protected by peremptory norms. In view of the contested nature of the doctrine of jus cogens, it is unsurprising, and despite many references to it in judgments and individual opinions, the ICJ has resisted this category of norms. It's not surprising because with all the advanced capitalist nations resisting the doctrine and wanting to actually dismiss it, the international tribunals have resonated that understanding. On the other hand, a reimagination of the scope of doctrine of jus cogens is called for if the international community is going to meet the many challenges that it is faced with, especially climate crisis. At present, both the jus cogens and erga omnes doctrines are given a narrow, negative, and status quo orientation, interpretation, and trust. What is called for is a forward-looking and positive orientation. It would, among other things, call for giving certain principles of environmental protection a jus cogens status. I personally found it more than odd that no environmental norm can be said to have just cogent status, even when the central challenges to humanity today comes from environmental crisis or the climate crisis, and whose consequences for many poor nations and marginalized groups is unimaginable. And even in the list which sought to be deleted, there is no norm related to environmental protection. And you would imagine that given the crisis, it would be on the top of the list, draft list that has been proposed by the ILC. If advanced capitalists refuse to assign key environmental norms such as status, at least the community of international lawyers must be forthright in expressing their views. Some scholars have, going against the grain, suggested that the no-harm principle, since it's already a norm of customary international law, is the most common basis for peremptory norms of general international law, and therefore has a candidate just cogent status. But even so, the doctrine of no harm is presently limited by the fact, as we shall see presently, that it is framed in the matrix of the logic of territory. The doctrine and principle need to be reframed by linking the concept of harm to the logic and history of capitalism. So I now turn to the reframing of some other doctrines of international law to address the crisis that is other than the jus cogens doctrine. A submission of these lectures has been that the modern doctrines of international law have been devoted to promoting the global capitalist order, in particular facilitating the defense of contractual and property rights. The fact that many of the very doctrines are now the sources for finding answers to the responsibility of states and corporations vis-a-vis the climate crisis explains their inability to provide effective responses. Put differently, the doctrines are not framed to address the consequences of what is aptly termed the era of capital or steam, as against the rather neutral term Anthropocene. It is also not entirely irresponsible to suggest that the doctrines of environmental law, and many scholars have argued this, are complicit in producing the climate crisis, not in providing a response, but are complicit in producing the climate crisis. For these doctrines rooted in the logic of territory can at best address the symptoms and not the underlying structural problems which require engagement with the logic of capital. In this backdrop, I first turn to the doctrine of no harm. As is well known, its classic statement appeared in the trail smelter case. It reads as follows, and I quote, "No state has the right to use or permit the use of its territory in such a manner as to cause injury by fume in or to the territory of another or the properties and persons therein." The doctrine is clearly articulated in terms of the logic of territory and was not centrally concerned with the protection of environment. And despite some forward movement in recent years in extending the scope of trail smelter doctrine to environmental protection per se, the no harm doctrine still suffers from, to use Jutta Brunel's phrase, significant constraints. In her view, and I quote, "The evolution of the rule beyond sovereignty paradigm has been only tentative, extending its reach to environmental harm in other states and much more weakly to environmental harm in areas beyond state jurisdiction." The restrictive scope of the no harm doctrine partly explains why, as Benoit Meyer observes, several recent ILC projects have dealt with environmental issues in a transboundary context, but global environmental issues, concerns have largely been left aside. The desire to keep out global concerns is also a reason for the opposition to the ILC project on the protection of the atmosphere. In short, because the no harm doctrine is tied to the logic of territories, its purview cannot be readily extended to the planetary consequences of the transactions between capital and nature. But if the dynamics of universal capitalism were taken into account, the focus would immediately shift to global environmental costs, such as protection of the atmosphere. If you move from the logic of territory to the logic of capital, the scope of the doctrine of no harm immediately gets extended. It would also bring into the frame global production and distribution systems that harm the global environment. In terms of the climate crisis, such reframing would have a bearing on the role of the state vis-a-vis fossil capital. To be sure, scholars have argued that even as currently framed, the doctrine of no harm is applicable to climate change. But if the logic of capital is factored in, it will conceptually move the doctrine beyond direct interstate harm between neighboring countries. More significant, it would bring, in my view, a sharper focus on the causes of climate change. It will thereby allow a robust interpretation of the due diligence obligations placed on states. At present, the due diligence obligations placed by the climate regime are, we are told by several scholars, not effective. An example of such reframing possibly is draft Article 7 of the 2014 International Law Association Principles on Climate Change, which among other things states, and I quote, in exercising due diligence, states shall take all appropriate measures to anticipate, prevent, or minimize the causes of climate change, especially through effective measures to reduce greenhouse gas emissions. When this understanding is read with a reframed doctrine of attribution, to which I'll come presently, the impact of both the doctrines will be deeper. The short point is, as Jutta Brune observes, responding to climate change requires agile, adaptable legal frameworks. Insofar as the doctrine of no harm is concerned, it has to be recognized that the standard of care is not fixed, it evolves in time. At present, the standard of care is so interpreted that it does not negatively impact capital accumulation. Another reason is said to be the possibility of the demand of full reparation for historic harm done to planet Earth and its consequences for poor nations. But that is also the legacy of global capital. In short, the real problem in extending the bite and scope of the no harm doctrine is the tension between preventing harm to environment and doing harm to the capital. And, there's no doubt which option is chosen by the international community of states. There's, of course, little doubt that combating climate change requires more precise negotiated primary obligations that can, in the final analysis, regulate the principal carbon producers of the climate crisis. But equally, relevant doctrines of international law need to be reframed so as to be able to provide another legal route for combating climate change. The need to reframe the no harm doctrine assumes importance, given that domestic courts are turning to norms of international law to evaluate the mitigation obligations of states. International tribunals may also come to consider the matter. As you would know, in January this year, Chile and Colombia have requested the Inter-American Court of Human Rights for an advisory opinion, and I quote, to clarify the scope of the state's obligations to respond to the climate emergency within the framework of international human rights law. This may call for consideration of the no harm doctrine. It is also possible that the ICJ and other international tribunals may come to be seized of the relationship between the no harm doctrine and climate change. A case therefore needs to be made out for a more robust interpretation of the doctrine by linking it to the logic of capital. Turning to the doctrine of state responsibility, what is required to address the climate crisis is a suitable doctrine of attribution linked to the harm done by both home-based and transnational fossil capital. As discussed in the previous lecture, it anticipates a reconsideration of the theory of state, which the doctrine of state responsibility have been framed. The argument is that once the theory of state changes, so does the doctrine of attribution. It may help to pause here and spell out the larger argument in the context of the climate crisis, of course, assuming that a primary obligation of a state has been breached. As Gunderson and Puyok have observed, and I quote, the assumption that bad corporations drive climate change is built on the misleading presupposition that fossil fuel corporations exist independently of wider political economic conditions. According to them, carbon-intensive industries operate within a wider carbon-intensive capitalist system that cannot constantly expand without their commodities, oil, gas, cement, petrochemicals, etc. Now, that capitalist system is enabled by the acts of omission and commission of the capitalist state. For example, one estimate is, and well known, that governments across 52 advanced and emerging economies account for 90% of the global fossil fuel energy supply, provide the fossil fuel subsidies worth an average of $555 billion per year from 2070 to 2090. But the numbers we are told are much greater if implicit subsidies are taken into account. The subsidies go up to trillions of dollars. In other words, once the term control in Article 8 of our SEVA is interpreted not in relation to a state, but a capitalist state, it acquires a different corporations. Once again, the complicity of the role of capitalist state in producing the climate crisis can be addressed either through harder primary obligations and reframing doctrines such as the doctrine of attribution, moving it beyond the effective control test. It is said that there are already in place alternative techniques to redress the shortcomings in the ICT-ILC doctrine of attribution. These include, according to Kristen Boone, and I quote, lowering thresholds of control, attributing responsibility for omissions, developing a duty to prevent certain acts subject to a due diligence obligation, and where circumstances and doctrine warrant, recognizing shared responsibility between actors. In this slide, Boone even speaks of the eclipse of general secondary rules of attribution. The concern with extending the rule of attribution to cover the acts of permission and commission of corporation has been that it would stretch almost to a breaking point the doctrine of state responsibility. That apprehension, in my view, is understandable. There are nearly 14,000 companies involved in dealing with climate change. States cannot be held responsible for all their acts of omission and commission. A suitable test, therefore, will have to be devised in this regard. A possibility is that for the state to be held responsible for corporate actions, it should have adopted policies and laws that lend the corporation the legal support, that is by way of subsidies, and create the legal space. Example, the absence of suitable regulatory rules to undertake production and allied activities that unduly contribute to climate change. In other words, we need to devise a test which ensures that the state is not held responsible for every act of commission of corporation. But it's not so difficult to devise such a test, depending by identifying those policies or whether political or legal, which enable fossil capital to unduly contribute to climate crisis. It may be mentioned in this regard that climate attribution science is transforming the possibilities of making corporations accountable. There needs to be a parallel development relating to the doctrine of attribution to make the state accountable. A reframed doctrine of attribution can, it is said, move the response from a pollution paradigm to a systems paradigm and compel the state to consider the possibility, among other things, of nationalization of fossil fuel companies. After all, Article 30 of the Rules of State Responsibility require the state attributed the wrong act to seize that act. And if the acts of the fossil capital have to cease, this has to come through attributing their acts of omission and commission to the state, which is the facilitator and creates the conditions in which fossil capital is operating. It may be argued that the best way forward is again not reclaiming the doctrine of attribution, but the adoption of primary rules accompanied by a lex specialis rule of attribution, placing stringent obligation on states. That is correct insofar as it goes. But the reality is that advanced capitalist states are unwilling to agree to such primary obligations or lex specialis rules. It may also be said that there are at present other pathways to ensure that states and corporations actively contribute to combating climate change. They are, among other things, secondary rules in multilateral environment agreements and treaties on civil liability regimes. There is the applicability of the general principles of international legal liability of states for environmental damage to climate change related damage. There is also the human rights route leading to climate litigation against states and corporations. It may be only observed in these regards that the reworking of the doctrine of attribution does not imply that other efforts to impose responsibility on states and corporates need to be given up. But as things stand, all these different initiatives haven't produced enough momentum to check fossil capital from accentuating the climate crisis. I now turn to another doctrine, the doctrine of necessity, and its possible reframing in dealing with the climate crisis. The doctrine of necessity has a complex, interrupted, and contentious history. Currently, the rule of necessity is a defense available under Article 25 of the Articles on State Responsibility. It precludes wrongfulness on the part of the state if three conditions are satisfied. First, it is the only way for state to safeguard an essential interest against a grave and imminent peril. Second, the act in question does not seriously impair an essential interest of the state or state towards which the obligations exist, or of the international community as a whole. And finally, the state in question has not contributed to the situation of necessity. A significant moment in the history of the doctrine of necessity was when it was invoked by Argentina in cases that arose out of its 2001 economic and financial crisis. In one or two instances, it received a favorable interpretation from an international tribunal, such as in LG&E versus Argentina. Again, realizing its potential to harm the interests of global capital, an attempt was made by other tribunals and researchers to limit the scope of the doctrine in a manner which parallels the effort to circumscribe the doctrine of jus cogens. Generally speaking, there's an attempt to strengthen the doubts as to the status of the norm of necessity as one of customary international law. Second, the scope of the doctrine is sought to be confined to a situation where the survival of a state is concerned. The contention is that Article 25 can otherwise be opportunistically used. As one researcher observed, and I quote, Article 25 is abstract, open textured language, such as essential interest, seriously impaired, and contribute to the situation leaves much to interpretation. What is at stake, it is argued, is that the certainty and stability of the legal system. From the standpoint of the climate crisis, a restrictive view of the doctrine of necessity may exclude the possibility of climate necessity overriding primary contractual or treaty obligations owed to fossil capital. In the past, the necessity rule has been pleaded in some cases involving environmental protection. The International Court of Justice in Gapchikovo-Nagimarov's case, and I quote, accepted that ecological interests could be essential for the purposes of the plea. But regular instances of ecological interests cannot be compared in depth and scale to the climate crisis. In the instance of climate change, there is no real uncertainty about there being a grave and imminent peril, especially in the case of states which are facing its immediate consequences. In many instances, there even comes into place the classic necessity test of threat to the very survival of the state, or what is called the right of self-preservation. In fact, we are speaking of a situation in which not merely an individual state, but the entire world is faced with grave and imminent peril. In other words, the state invoking the necessity test to trump obligation owed would be protecting a core and vital interest of the international community. It would be in accord with the ILC community, which states that the crucial matter is whether, and I quote, the interests relied on outweighs all other considerations, not merely from the point of view of the acting state, but on a reasonable assessment of the competing interest, whether these are individual or collective. In view of the fact that curtailing of carbon production is the principal way forward, the invocation of the doctrine of necessity to compel capital to accept departure from a treaty or contractual relationship is only just. Put differently, the doctrine of necessity has to be reframed to take cognizance of the history of capitalism and the role of fossil capital today. If that is not done, the state invoking the doctrine of necessity will encounter the weaponization of the investor-state dispute settlement system. That is, it will be weaponized by the fossil fuel industry. According to a report on investor-state disputes in the fossil fuel industry, this is focuses only on fossil fuel, the ISDS system, and I quote, can present a major obstacle for countries seeking to phase out fossil fuels. In fact, the report points out that in recent years, there's been growing, and I quote, wave of arbitrations initiated to counteract specific climate measures, such as the phasing out of fossil fuels. What is disturbing, according to the report, is that the majority of the known fossil fuel cases are decided in favor of the investors. Finally, the report notes that the lower middle and upper middle income countries receive the highest number of claims related to fossil fuel investment, while 92% of the investor claimants are from high income countries. American investors initiated almost 30% of the fossil fuel arbitrations. In another intervention through a blog post in July last year, the Center for Environmental Law, the International Institute for Sustainable Development, client right of the Energy Charter Treaty that, and I quote, there is increased recognition that the Energy Charter Treaty's ISDS mechanism serve as an obstacle to such effort, that is phasing out fossil fuel production. This was also acknowledged by the International Panel for Climate Change in April 2022. The refurbished or modernized Energy Charter Treaty, despite some references to climate change, may not substantially alter matters. As has been observed, it remains to be seen whether the cosmetic language changes in the Energy Charter Treaty will prove effective in practice. Meanwhile, on a positive note, since October 2022, 7 EU member states, France, Germany, Spain, Poland, and Netherlands, Luxembourg, Slovenia, have announced plans to withdraw from the Energy Charter Treaty. And I hope this happens, because at the end of the day, life has to prevail over the logic of capital and traditional doctrines of international law. It would be a shame if international arbitral tribunals dealing with investment disputes continue to prioritize the interests of capital against that of the international community. A reframed doctrine of necessity would make a difference. It could also contribute to the adoption of a new set of investment agreements, giving much more greater policy space to host states. I finally turn to another doctrine. The point I'm trying to make is, going through these different doctrines, is that if they are reframed, keeping in view the logic of capital, and then they could become much more effective in dealing with the climate crisis. As it stands, the doctrines are unable to effectively respond to the climate crisis. And on the other hand, fossil capital has weaponized the interstate dispute settlement system to prevent states from phasing out fossil capital. I now turn to another doctrine, the Rebuk-6 Tantalus doctrine, which also needs to be reframed. Article 62 of the Vienna Convention on Law of Treaties, which codifies the doctrine and speaks of the impact of a fundamental change of circumstances on a treaty regime, requires several conditions to be met for its applicability. These are at least 5. First, there must be a fundamental change of circumstances. Second, it must be with regard to conditions which existed at the time of the conclusion of a treaty. Third, it was not foreseen by the parties. Fourth, the existence of those circumstances constituted an essential basis of the consent of the parties to be bound by the treaty. And 5, the effect of the change is radically to transform the extent of obligations still to be performed under the treaty. The VCLT form, or the Vienna Convention formulation, represents a restrictive view of the doctrine and was intended to lend stability to treaty regimes based on the logic of territory. It was never intended to deal with the logic of capital. As the International Court of Justice observed in the Gapchikov Nagamura case, and I quote, the negative and conditional wording of Article 62 of the Vienna Convention Law of Treaties is a clear indication that the stability of treaty relations requires that the plea of fundamental change of circumstances should be applied only in exceptional cases. There have been in the past other formulations of Rebecca's stantibus doctrine, at least one of which, the vital interest view, has been reportedly invoked in recent years by some states. This version, in the words of the ICJ, represents the traditional view that the change of circumstances which must be regarded as fundamental or vital are those which imperil the existence or vital development of one of the parties. In this version, as Kulaga points out, the move is from shared expectations approach that takes intention of all parties to a treaty into account, to an approach that puts more emphasis on the treaty's adverse effects on a single party. This understanding was not endorsed by the ILC in the Vienna Convention. The only point I wish to make here is that which version of the Rebecca stantibus doctrine should prevail depends on the times and goals that the international community is pursuing. Put differently, the question is, should the ILC formulation on change of circumstances itself be subjected to re-evaluation today because of the change of circumstances, so that the principles of the Rebecca doctrine apply to the doctrine itself? There is already some reflection on the invocation of Rebecca stantibus doctrine by a state to address the climate crisis. Baker, for instance, argues that, and I quote, the doctrine might be applied to modern circumstances to provide much needed flexibility to international economic law in light of climate change. A state wanting to exit or renegotiate an investment agreement could contend that the presupposed stability of environment constituted an essential basis of the state consent to be bound by an investment agreement, and that the changes to the climate radically transform the state's obligations under the agreement. Such a view would also mean the fisheries jurisdiction test, that the change of circumstances, to quote the ICJ, must have increased the burden of obligations to be executed to the extent of rendering the performance something essentially different from that originally undertaken. The argument is that clearly the Rebecca stantibus doctrine is applicable. But we have to pause here, because at least one reason that commentators are turning to the Rebecca stantibus doctrine is that it is seen as much more reasonable in addressing the problem than the doctrine of necessity, because the doctrine of necessity allows you to actually call curtains to a treaty or a contract, whereas the Rebecca stantibus doctrine lays down certain conditions that need to be met. Arsanjani Riesman has recently written that, and I quote, the Rebecca stantibus doctrine may function as a stabilizing doctrine for maintaining and possibly adjusting treaty regimes in an orderly fashion, as it allows for both an objective test and also one that must be pleaded before a third-party arbiter. For this reason, Rebus operates within control limits. Rebus offers an international tribunal the opportunity to set out a fair termination or revision of a climate-impacted treaty. So she's suggesting that the Rebus doctrine is a better move than the doctrine of necessity, at the third-party arbiters come into the picture, and it also provides certain objective tests. In speaking of stability and fairness, this view does not adequately take into account the record of fossil capitalism, nor does it take into account the record of the ISDS system that I just mentioned. What is fair and what is objective when interpreted in the matrix of the logic of territory, the global capitalist order, and the restricted ILC view can mean outcomes that favor the interests of fossil capital. On the other hand, if the logic of universalizing fossil capitalism and global harm informs fairness and objectivity, the interpretation of fundamental change can be used to take into account vast contribution of fossil capital to climate change, the downside of the operation of a particular investment regime, the harm caused to the survival of the international community, and the goals of international climate law. In other words, if these latter factors are taken into account in interpreting fairness or objectivity, the result would be somewhat different from that which has been anticipated by scholars who are recommending the Reframing doctrine. There are, of course, a number of causal and evidentiary issues involved in considering fundamental change of climate circumstances and the possibility of opportunistic use by states. The point I merely wish to stress is the need for reframing the Reframing doctrine in the face of the contribution of fossil capital to global warming. Put differently, there's an urgent need for an imaginative interpretation of the Reframing doctrine in the context of the climate crisis, if we are to prevent its use by fossil capital to advance its own interests. I can only hope that I've said enough to illustrate how doctrines can be reframed by foregrounding the logic of capital along with the logic of territory. However, much of what I've said is in relation to the climate crisis. But what about the range of other crises with us or on the horizon? In the case of each crisis, particular doctrines may be involved that may need to be revisited and reworked. It may be one set of doctrines with respect to the law of the sea or international space law, and another set in the case of international trade law or international digital law. But in most cases, the fundamental doctrines are involved with the doctrine of sources in all cases. It is there we must begin. For instance, the doctrine of customary international law assumes the different meaning when cognizance is taken of the fact that state practice, in the absence of the state practice of developing nations being mostly unavailable, is the practice of advanced capitalist states or imperialist states. Likewise, the doctrine of state responsibility and attendant doctrines is significantly shaped by the practice of imperialist states, both past and present. The doctrine of jurisdiction and extraterritorial jurisdiction also legitimizes the practices of the same nations. In fact, the doctrine of jurisdiction and extraterritorial jurisdiction are the necessary outcome of the historical tension between the logic of territory and the logic of capital. While capital is extraterritorial by nature, the logic of territory is about territorial constraints on its movement. It is, however, not enough to critique these doctrines, but to come up with workable proposals of reform. In that spirit, I have in my recent writings on the doctrines of customary international law and jurisdiction tried to advance some ways of reforming these doctrines. Many others have also done so in relation to these and other doctrines. But those demanding alternative formulations must remember that the present doctrines have been shaped by mainstream publicists over a long duration and supported by power. Their reform will surely take time and can only be undertaken collectively by critical scholars. I would suggest that individual scholars be increasingly accompanied by a group or team scholarship to address the question of reform of particular doctrines. Be that as it may, the task should not be neglected. It is time to conclude. Allow me to begin at the beginning, and I won't take too long. In the preface to his monumental history of science, titled Science and History, the eminent British scientist J.D. Bernal wrote that, and I quote, that capitalism and modern science were born in the same movement. I have argued that the same is the case with modern international law. But as he hastened to add, to write this, however, is only to begin to state the problem. These rough equations between social and scientific developments give rise to a central question. How in detail does a social transformation affect science? He also proposed in this regard a periodization and sub-periodization of the development of capitalism. Bernal's work has been challenged and subsequently other histories of science and capitalism have been written. Yet his pioneering work was critical to the writing of a realist history of modern science. But insofar as modern doctrines of international law are concerned, there's nothing like the Bernal efforts to be found in the literature. There is even today little effort to explore the relationship between capitalism and different doctrines or distinct historical phases of doctrine development. To be sure, the influence of capitalism can be sometimes direct and other times subtle and inobtrusive. It is, however, the deep structures of capitalism that provides context and relevance to the doctrines of international law. So much so that it never needs to be named. Such is the influence of capital that you can have a 1,000-page textbook on international law, and the word capital never is uttered. So it is a given. It is the natural order of things. Therefore, when individual scholars reflect on problems or responses in the world of international law, it is overlooked that these are thrown up in many instances by the working of global capital. Likewise, the epistemology of doctrines and doctrinal research and the relationship to bourgeois ideology has only rarely been explored. So is the case with the ontological basis of doctrines. The world of social facts and the weight to be attached to them is in many cases determined by hegemonic ideologies. It allows doctrines and doctrinal materials to be shaped to support a particular vision of the international order. The understanding of state and state practice used to frame doctrines, especially the doctrine of sources and state responsibility, facilitates this effort. But no attempt is made to capture their relations with power and capital. Such a move would help recognize the class, gender, race, and caste dimensional effects of the doctrines of international law. Put differently, the making of doctrines wedded to the logic of territory and a particular understanding of the state are designed to advance the cause of global capitalism. In short, the existing doctrinal architecture cannot assist in meeting challenges thrown up by the capitalist order. International lawyers are trapped within doctrines that urgently need to be reimagined. We need to open up new ways of thinking about the doctrines of international law and their role in the global capitalist order. Legal doctrines need to transmute to meet present-day needs. The world is also changing at a rapid pace as a result of what has been called the Fourth Industrial Revolution. The doctrines of international law must also keep pace. The doctrines cannot only be about protection of contractual and property rights. They cannot neglect the fate of weak nations or the poor, marginalized, and oppressed groups only on the basis of suspect technical arguments. To be sure, the proposed doctrines should be touched by a sense of realism. What is possible is not revolutionary overthrow of bourgeois doctrines, but their reworking. In this regard, last but not the least, I want to mention that the pedagogy of international law calls for deep collective reflection. We cannot continue to socialize the next generation of international law scholars into suspect or inadequate doctrines. There is already a sense of growing alienation from the existing doctrinal framework. Its fetishization has become an obstacle in addressing multiple interlocking crises that humanity confronts. I want to conclude this lecture with the hope that in the coming years, the teaching of international will involve the close questioning of prevailing doctrines of international law and the possibilities of their reform to meet growing challenges. Thank you so much for your patience and indulgence. Thank you very much.
Thank you very much indeed for really another magisterial lecture. It's really been a tour de force and a great pleasure to welcome you here to hear from you.